Hello there, my name's Levent Altan. I'm the Director of Victim Support Europe. And first of all, I'd like to welcome you and thank you for joining us on this important course, and thank you for your commitment to victims. I know that your participation will have an important impact on their lives and help ensure that they are treated in a proper manner and help with their recovery. What I propose to do is a quick introduction as to who I am and who Victim Support Europe is, before talking to you a little bit about the background to the EU Victims Directive, followed by a session on Article 2, which is on the definition of victims. So, by way of introduction, Victim Support Europe is a European network of victim support organisations and other experts within the field. We have 27 members in 27 countries. And we work to ensure that victims' rights and services exist across the EU and across Europe. And we do that through lobbying and advocacy, the development of policy, and through capacity building at the national level in countries. In terms of my background, I was a civil servant in the UK Ministry of Justice, working on policy and law developments before I was seconded to the European Commission, and there I worked to develop the EU Victims Directive and to negotiate it in Council and Parliament. So I have a pretty good understanding of why the directive is designed and structured as it is. So I'll spend a few minutes just to maybe explain a little bit about that. I think it's very helpful to know. And the starting point really is that rather than thinking about how victims can adapt and should adapt to the system, the aim was to understand the needs of victims so that our systems are developed and adapted to those needs. And why is that important? It's important from a humanitarian perspective. It really helps to reduce the harm that victims suffer, and it helps them to recover. But it's also important from an economic perspective and from a justice perspective. The better we treat victims, the quicker they will recover, the less harm that's caused, the less economic hardship that results. But it also means that our justice systems will work better. People will be more willing to come forward and report a crime, and they will be more willing to continue with that process through to the end, and they will be better witnesses as a result of those better processes. So effectively it's a benefit to everyone. So the starting point of the directive is the needs of victims, and we look at that from 5 broad categories of needs which all victims of crime exhibit. And you can summarise those as the need for respect and recognition, respectful treatment and recognition as a victim, the need for protection from further harm, but also protection from the system, from being harmed by the processes and by people and the actions or inactions that they take. Victims also need support, a whole range of different forms of support, whether that's emotional and psychological, whether it is practical, information, financial aspects, a whole range of different support needs can be seen amongst victims. Victims also need access to justice, and they want to participate in that process, and they also want compensation and restoration. So these are the 5 basic needs of victims, and that helps structure the directive, and it helps structure the way that we approach the entire area of victims policy. Also fundamental to the directive is an individualised approach, of an individualised and targeted approach, and that means really within our systems being able to flex to the specific needs of each individual victim, and being able to target the specific needs and provide responses appropriate to those needs. And what this really means in reality is not that the entire system has to meet every single aspect, but simply that there is some level of flexibility within the system. And when trying to understand or learn about these needs, it's helpful to, I think, visualise the the needs of victims in a pyramid. And in this foundation at the base, we have the 5 common and general needs, which you can see amongst all victims. And then in a layer above that, we can see needs which are generally relevant and applicable to certain groups of victims. So it may be victims of certain crimes, such as domestic violence or terrorism, have certain specific needs, and responses need to be adapted to those needs. Or it may be victims from specific groups, such as victims with disabilities, or from an ethnic minority, for example, or foreign victims. And they will have their own specific needs as well. And above that layer, we have needs which are specific to every individual and based on their certain characteristics. And when determining these needs, we can see that they're really determined by the personal characteristics of the individual, so their ethnicity, their gender, their age, for example, but also their environment and their situation, their history of crime, for example, and of experiencing crime. Or the area of the country that they live in, whether they're poor or rich, how much crime there is in that area. All of these situational aspects will affect their needs and their vulnerabilities. And then at the very top we have those specific personalised aspects of a victim, such as if they've previously experienced crime before, that has a huge influence on how they're subsequently impacted by new crimes. Or, for example, if they've lost a loved one recently, that can have an impact on what they need and how they experience crime. So their personal needs, they may have drug dependency, for example. If you have children, that you may find difficulties in attending certain interviews or testimonies or hearings. So there are personal aspects for each individual victim. And that pyramid helps us then to think about how to design our systems so that they can both operate in an effective and an efficient way, but also in a flexible and targeted way. And what that means, for example, is that we generally recognise that children are vulnerable and need specific help when going through our criminal justice system. And so we can have measures in place to shortcut any kind of analysis around this. And we say, generally speaking, children should be afforded certain protection measures, such as giving testimony via video link. But we should also have flexibility in the system so that there are children, such as a 17-year-old who wants to confront their attacker, wants to be able to give testimony in court live, and wants to see that person face to face when they're giving testimony. And they should have that possibility, and there should be the possibility within the system to allow for that. And similarly, it's important that within this system, we don't establish rights and measures for just one group to the exclusion of all the other victims. Because generally speaking, it may be just that one group which is the most in need of a particular measure. But as I've said, based on the personal characteristics, history, etc., other victims may be in need of that particular measure and may greatly benefit from it. And so there needs to be that flexibility to take these matters into account. And how do you do that? You do that through assessing the needs of victims, and really working out what is the situation, what is the personal background of this individual, and what are their vulnerabilities, fears, and what are their needs. And in the EU Victims Directive, there is a needs assessment, particularly for protection measures within the justice system. But within the support world, victim support organisations will carry out a much broader needs assessment in the intake process, and really find out what's happening with that victim, so that they can understand what the global response needs to be. And ideally, those two types of assessment will be joined up so that a victim is treated in a holistic manner. Victims are affected in the entire aspects of their life, and not just with respect to the law, or with respect to support, or with respect to school. So this is the starting point for the directive, focused on the needs. And if we any actions we carry out, whether personal or legal or policy, if we start everything from the perspective of what do victims need, then we are in the best position to get it right, and therefore to benefit from those measures. So that's a little bit about the background to the directive. You can see, therefore, in the structure to the directive, there are chapters on information, support, protection, access to justice, and that's designed around those needs. And we see that there are needs assessment, there's references to personal characteristics. So we see how this directive has been developed with those areas of focus. In this second session, I just wanted to talk a little bit about the definition of victim under the Victims Directive. And that's Article 2 of the directive, and it refers to a victim as being a natural person who has suffered a range of different forms of harm, or at least one of those forms of harm, as a direct result of a crime, as defined under national law. And it also includes the family members of people who have been killed as a direct consequence of a crime. So the starting point of this, of course, is that it's a natural person. This means under the directive that companies are not included within that, or legal persons are not included. And that was decided that way simply because this was an extensive directive already, and it was difficult to determine the relevance and importance and implications of also including legal persons within this directive. So it's not to say that in the future it would not be right to cover legal persons. It's not to say that member states themselves should not cover legal persons. And of course the directive always allows member states to go beyond the directive. So that's a starting point in terms of the definition. Then going on to two important issues. One is around the term victim, the other is around the recitals in the directive, which talk about the fact that a victim is a victim irrespective of whether the offender has been apprehended, convicted, irrespective of any familial relationship. So there are these two issues. And what's important to know is that this definition is not new. It's been around at least since 1985, when the UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power was adopted. So we have since 1985 a definition which is almost identical to the directive. The Council of Europe, in its recommendations, have followed that definition. The 2001 Framework Decision broadly followed that definition. What's new compared to the Framework Decision is the issue of family members. So a small group of victims who have lost a loved one as a result of a crime. So this directive is not really trying to be bold or different in terms of the definition. It's well established, well known. In terms of the term victim, for me, I've not seen any indications from the Commission that using a different term to victim is in itself problematic. So across the European Union, different member states have different approaches and a long history of the terminology. So in some countries we'll see they use the term complainant, in other countries we see injured party, in others something else. So there's different terms which broadly encompass the notion of victim. I don't understand that that in itself is problematic. What is much more important and fundamental is whether the definition behind that term encompasses all of the victims as envisaged by the directive. And here there's two issues to also take into account. And that is that the directive itself differentiates between those rights which are accessible to all victims of crime, and those which are relevant to those victims in accordance with their role in criminal proceedings. So I won't go into the details of the role of criminal proceedings, but there are certain rights, such as interpretation and translation, which are limited only in accordance with the role. And that could be, for example, where a victim is actively participating as a civil party. And it's determined by each member state's system and by their decisions. So that needs to be borne in mind when looking at what rights are accessible by which victims. But in terms of the notion of victim itself, it's fundamental that there are certain rights which are available to all victims. So irrespective of what term you use, whether it's complainant, victim or injured party or anything else, you should not have a system which results in certain victims not having access to these rights. If your only way of determining rights is by the notion of injured party or complainant, and that complainant only exists as a notion at a certain point after a crime has been formally reported, you will have difficulties in terms of the implementation of the directive, because the right to information exists from the moment that a victim has contact with an authority, and that authority is aware of the victim. So that may be that they come to the police station and inform the police and want to get some information without making a formal report or complaint. And there they need to have access to these rights. So this is an example where you can, as a result of your definition, exclude certain victims and exclude access to rights. Another example might be where within the civil party system, victims have the choice whether they want to be a partie civile or not. And some may choose not to do that, and yet under the directive they still have the right to, or should have access to a certain number of rights. So the system in place in any particular country needs to take this into account and needs to ensure that those rights still remain available to those victims, irrespective of the decision whether to take part as a partie civile or not. So without saying what is a correct implementation, the fundamental basis is that it's not necessarily problematic that the term victim is not used, but whatever terminology is used, the definition needs to be compliant with the directive, should not include victims from the rights which are established in the directive, and where a certain terminology is used which is exclusive, a system needs to be developed which ensures that all victims have access to all rights. And that may be a new term, a new definition, it may be having two definitions. I can't say what's the correct approach there. The Commission, I think, will have to make those decisions. A second aspect to the definition of victims is this notion that a victim is a victim before there is a conviction. This is absolutely fundamental to victims' policy. It's absolutely fundamental to victims themselves to be believed from the outset. It is as important to victims as the presumption of innocence is to the defendant and to defence rights. It's absolutely fundamental. The idea that we say to a victim, well, we don't believe you, effectively, until somebody is convicted, is contrary to that needs-based approach. It will result in fewer people wanting to come forward, it will result in more people dropping out of the system, and it will result in significantly more harm to victims. And we know for certain types of crimes such as rape, sexual offences, that this is, even with this presumption of unbelief in the victims, that victim blaming, victim myths contributes to a significant amount of harm to victims, and then the belief in the victim, the definition of victim, and the harm and the success in a justice system are all interlinked. And this notion that you can be defined as a victim throughout that process and before any kind of conviction does not in any way undermine the presumption of innocence. It is not saying that this person before us is guilty of a crime. It is simply saying we believe that there is a victim here until proven otherwise. There are some good examples of how this is relevant for it. It could be that a case ends with a finding of no criminal liability, but not because the act did not occur in itself, but because the person was too young to be found criminally liable, or they weren't of sound mind. Maybe an investigation never arose because they could never find the criminal. In these days where we have now significant amounts of cybercrime, cross-border crime, these issues become increasingly important. And if we think about, and if I think about the history of the directive, the defence rights and rights of fair trial have been absolutely paramount in discussions and in the development of the directive, both in the consultation process, in the writing of the directive, and in its negotiations. There are numerous articles and numerous points where the rights of the defence are referred to, where fair trial rights are referred to, where the rights of the offender are referred to. So there has always been this particular concern that the directive does not in any way impinge on the rights of the defence. And in actual fact, the entire movement for victims is based around raising the position of victims and their rights, not diminishing the rights of the defence. And the two can and are achieved parallel to each other. And it's only in a small number of issues or cases where decisions have to be made around balancing rights, and I think that that's perfectly reasonable. For example, with respect to protection measures, judges are left with that kind of decision, what measures should be put in place, what might be the impact on defence rights, and what will be the appropriate approach to take. So this system works, the defence rights are always taken into account, and it's the same for the definition of victim. The definition of victim is long-standing, it's not new, there isn't a question of it impinging in any way on the rights of the defence, and it is absolutely fundamental to getting it right for victims. So I think with that, I'll end this particular presentation, and I hope you have a very successful rest of your course. Thank you.